2 days before Christmas, with lights glowing across the neighborhood and families settling into holiday routines, an HOA board believed they had finally silenced the one homeowner who refused to fall in line. Fines had stacked up, threats had escalated, and foreclosure paperwork was already prepared. From the board's perspective, the message was clear: compliance or consequences. What they didn't realize was that this quiet resident had spent his holiday nights preparing something far more devastating than an appeal or complaint. While the HOA congratulated itself on another win, a lawsuit was quietly filed that would expose years of abuse, unravel their authority, and turn a holiday power play into a legal nightmare they would never forget. The neighborhood of Evergreen Pines looked like it belonged on the front of a holiday catalog. Neatly aligned homes, trimmed hedges, matching mailboxes, and seasonal decorations carefully arranged to meet HOA standards. It was the kind of place that advertised order, stability, and predictability. The Homeowners Association took pride in that image, branding itself as strict but fair, protective of property values, and unwavering in enforcement. Daniel Carter moved into Evergreen Pines 3 years earlier. At 42, he lived a quiet, disciplined life, working remotely as a real estate attorney. He wasn't particularly social, but he was courteous, paid his dues on time, and followed the rules closely. When he bought his home, he read the HOA bylaws carefully, not out of suspicion, but habit. He noticed vague language and broad enforcement powers, but like most people, he assumed conflict was unlikely if he stayed compliant. For years, that assumption held true. Everything changed in November. The first violation notice arrived without warning, citing unauthorized holiday decorations. Daniel's offense was simple: warm white lights along his roofline. The fine was modest, but the accusation made no sense. According to the bylaws, holiday decorations were permitted starting mid-November. The date on the notice was already past the threshold. Daniel responded politely, citing the exact rule and attaching a photo. The reply he received from the HOA president, Linda Hawthorne, was brief and dismissive. The board, she claimed, had discretion. The lights needed to be removed. That single exchange marked the beginning of something far larger. Within days, additional violations appeared. His trash bins were allegedly visible too long. His mailbox paint was described as faded. Even the size of a decorative wreath was suddenly an issue, despite no such measurement existing in the rules. Meanwhile, neighboring homes displayed far more elaborate decorations without consequence. When Daniel attended an HOA meeting to address the issue, he was cut off repeatedly, denied meaningful time to speak, and reminded that the HOA always prevailed. That phrase stayed with him. Behind the scenes, Daniel began documenting everything: emails, notices, photos, meeting minutes, and records requests. When he asked for financial documents, something homeowners were legally entitled to review, the HOA delayed, refused, and eventually claimed the records were unavailable. By mid-December, the tone shifted from petty to threatening. A certified letter warned of a possible lien due to ongoing non-compliance. Another hinted at foreclosure if fines weren't paid promptly. Neighbors began to whisper, some offering quiet sympathy, others distancing themselves out of fear. On December 22, the HOA delivered its most aggressive threat yet: a demand letter giving Daniel 10 days to pay escalating fines and legal fees or face foreclosure proceedings. 10 days spanning Christmas. That night, while Evergreen Pines glowed with holiday lights, Daniel sat surrounded by documents. He wasn't angry. He was methodical. He recognized patterns of selective enforcement, denial of due process, and abuse of authority. He also knew something the HOA did not. He knew the law. Christmas week arrived without peace. On December 24, another notice appeared, this one slid under Daniel's door. It cited an emergency board decision declaring his driveway an environmental hazard due to alleged oil stains. The fine was steep, and the notice warned that HOA-approved contractors could be dispatched without consent. The driveway was spotless. When Daniel requested evidence, the HOA responded with a single sentence declaring the board's decision final. Over the next several days, violations multiplied. His architectural file was suddenly incomplete. His vehicle was allegedly parked improperly in his own driveway. A surprise compliance inspection was scheduled without permission. Each refusal or challenge generated another fine. The HOA's attorney soon entered the picture, issuing a demand letter listing thousands of dollars in fines and projected legal costs, once again threatening foreclosure. Daniel continued documenting everything. As he reviewed records and spoke quietly with neighbors, a disturbing pattern emerged. Many residents had faced similar emergencies in the past and had been forced to pay the same contractor for unnecessary work. That contractor, Daniel discovered, was closely connected to the HOA president. The relationship had never been disclosed. Neighbors who had once been afraid to speak began sharing their experiences. Each story added weight to Daniel's growing case. Formal requests for mediation and hearings were ignored. On New Year's Eve, the HOA issued a pre-lien notice with a 3-day deadline. It was meant to force submission. Instead, it triggered action. On January 1, Daniel filed a detailed civil lawsuit naming the HOA, its board members, the management company, and its attorney. The claims included selective enforcement, abuse of authority, denial of due process, conflicts of interest, and intentional financial harm. He also requested an injunction to halt enforcement actions across the entire neighborhood. By the time the HOA realized what had happened, the legal machinery was already moving. The emergency court hearing was set for early January, and panic spread through the HOA leadership. Emergency meetings were called. Attorneys requested delays that were denied. The confidence that had defined the board evaporated. The courtroom was crowded with homeowners, many attending an HOA-related legal proceeding for the first time. Daniel presented evidence calmly and methodically. He showed contradictions between bylaws and enforcement, proof of selective punishment, refusal of records, and financial irregularities. He demonstrated how emergency powers had been misused and how fines functioned as retaliation rather than compliance. Then came the internal emails instructing management to make an example of him. The judge granted the injunction in full. All enforcement actions were halted. Fines were frozen. Liens were prohibited. Financial records were ordered to be released. Evidence of misconduct was referred to regulators. The fallout was immediate. The HOA's attorney withdrew. The management company terminated its contract. Board members resigned. The president stepped down as investigations began. Facing overwhelming exposure, the HOA settled. All fines against Daniel were dismissed. His legal fees were paid. Enforcement policies were rewritten. Audits were mandated. Homeowner rights were expanded. The board's authority collapsed under scrutiny. The weeks that followed were quiet. Notices stopped. Threats disappeared. The HOA's online portal fell silent. For the first time in years, Evergreen Pines existed without constant pressure. The independent audit revealed extensive misuse of funds, inflated contractor fees, and inconsistent penalties. Homeowners who had once been fearful began attending meetings in numbers never seen before. Transparency became a demand rather than a suggestion. Culturally, the neighborhood shifted. Fear gave way to confidence. Decorations stayed up. Communication softened. The HOA transformed from an enforcement machine into an administrative body bound by rules it could no longer bend. Daniel returned to his routine, never seeking recognition. His house remained the same, but its meaning changed. It became a symbol of what happens when knowledge meets persistence. Beyond Evergreen Pines, the case rippled outward. Other HOAs quietly adjusted their policies. Advocacy groups shared the story. Attorneys cited the precedent. The conflict had begun with Christmas lights, symbols of warmth and celebration, and ended with the exposure of a system built on unchecked authority. It reminded homeowners that power depends on silence, and silence ends when someone finally decides to read the rules and ask questions. The lights continued to glow each holiday season, no longer as a source of conflict, but as a reminder that authority is never absolute, and even the smallest acts of resistance can reveal the truth. If one homeowner could expose so much by refusing to comply quietly, how many other communities were still living under the assumption that power, once claimed, could never be challenged?